Welcome to the first ever podcast by the Mishiyeva law firm. We are located at 85 Broad Street in Manhattan, New York, within the financial district. Our number is 646-736-6328. Just to give you an introduction of what our firm does, we specialize in estate planning and bankruptcy law. The founder of our law firm, Mishiyeva, is a graduate of Rutgers Law School. You can check out her sites at nycprobatelawyers.com and kmbankruptcylawyerny.com. She is available to assist clients within the 5 boroughs of New York, Long Island, and the surrounding counties of New York City. For the next few episodes, we will mainly focus on estate planning. We will give you an introduction as to what it's all about. So, to get right into it, what is estate planning? Well, according to Wikipedia, estate planning is the process of anticipating and arranging during a person's life for the disposal of their estate. Estate planning can be used to eliminate uncertainties over the administration of a probate and to maximize the value of the estate by reducing taxes and other expenses. So that was a little long-winded. So what I want to do is give you our definition of what estate planning is. To give you a broad answer, it is the process of making the uncertainties of life more certain. This applies to your finances and to aspects dealing with your health. It's all about managing your wealth and knowing what actions should be done on your behalf when you're unable to make decisions on your own due to medical issues. So what are some tools used in estate planning? There's something called a healthcare proxy. Let's say you end up in a coma. By establishing a healthcare proxy, you appoint someone with the authority to decide on whether you should stay alive or have the plug pulled. Obviously, this proxy is established while you're in a sound state of mind. Then you have what is called a will. A will is essentially your final say on what should be done with your assets. Should they go to your children, your wife, an organization, or all of the above? There are a few definitions you should know when it comes to wills. With a will, you appoint what is called an executor. This individual manages the assets in your estate, deals with paying off any required taxes, pays off your creditors, and eventually disperses the remaining assets to your beneficiaries. A beneficiary is the person who you named in your will to receive your assets. As the name suggests, they benefit from all the assets you accumulated during your lifespan. An estate is basically everything you own. Your checking account is part of your estate, along with your clothing, your couch, your boats, and your cars. When people hear the word estate, they sometimes think it only applies to the wealthy, but that is absolutely false. It applies to anyone who owns anything. Then we have what is called a trust. According to Fidelity.com's website, a trust is a fiduciary arrangement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. Trusts can be arranged in many ways and can specify exactly how and when the assets pass to the beneficiaries. So, to give you an example, let's say you leave behind a trust for your grandson. You name a trustee, and the terms of the trust state that your grandson will receive X amount of money if he gets admitted into an Ivy League university. The third party is the trustee, who has the fiduciary duty to disburse assets in the trust only when your grandson gets admitted to Yale or Harvard or another similar school. Let's say he doesn't get into a school that's an Ivy League. What happens next? Absolutely nothing. The trust was only arranged to become effective under one particular occurrence. So, while we're still talking about trusts and wills, there's something called the probate process. So the probate process happens when there is a will. It's essentially the process where the will is validated by surrogate's court. And what is surrogate's court exactly? It's the court that basically oversees trust and estate administration. So why exactly does surrogate's court want to validate a will through the process called probate? Well, usually there's 3 things that could have happened when this will was created. Number 1, fraud could have occurred. It could be a fake will. Number 2, undue influence could have occurred. And what that means is the decedent, which is the person who has now passed away, who created the will, was coerced by one of the beneficiaries to make this will. And the third item that would be a red flag for the for surrogate's court would be if the person writing the will or the decedent might have been drunk or on drugs or just not in the right mental state to be drafting a will. So the court takes this very seriously, and there's a process that sometimes takes months in order to ensure that the will is in fact valid. The evidence has to be shown, witnesses have to come, the will itself has to be valid. A lot of things take place during the first 8 or 9 months after the will is submitted to the court. Sometimes it takes a little longer, sometimes it takes less time. But you have to keep in mind, a trust avoids the probate process. Yes, trusts can be more expensive than drafting a will, but at the end of the day, you save a lot more money on attorney fees and other expenses. And then finally, we have what is called a guardianship in the realm of estate planning. Now, keep in mind there are a ton of different types of trusts and other vehicles out there that deal with estate planning, but today we're just giving a quick overview of what are some of the main estate planning tools that exist. So what's a guardianship? According to nyc.gov, a guardianship is a formal and legal arrangement granted by a court that gives another person the legal rights to act on behalf of a child whose parents are dead or missing, or otherwise not able to care for the child. So within the realm of estate planning, I think the term guardianship is a little more broad. Not only does it deal with a child whose parents passed away or are not able to take care of the child due to various reasons, a guardianship also refers to a child who is in their 30s or 40s who just cannot take care of themselves. And so what the parents do, or what a particular guardian might do, is file for guardianship, and if allowed, they will have the authority to pay for this child's or this person's expenses, take care of them financially and physically, essentially. So a guardianship applies not to children, but it applies to adults as well. So that pretty much concludes our quick overview of the various tools within the estate planning world. Again, we're the Mishiyeva law firm. We're located at 85 Broad Street in Manhattan, New York, within the Financial District. Our number is 646-736-6328. For the next few episodes, we're going to be going into more detail about these various estate planning vehicles. We're going to talk more about trusts and what kind of trusts exist. We're going to go into wills and what are all the various clauses that you might see in a will. And before we end off today, I just wanted to let everyone know something. If you're looking to make a trust or a will or a guardianship, or someone passed away and there's a will that needs to be probated, you have to understand that an estate planning lawyer, or what's otherwise known as a probate lawyer, understand this process better than you probably do. Granted, you might have went to LegalZoom and you think you know a couple of things about wills and trust, which is great. However, an estate planning lawyer has had the training, has had the education, and has had the experience of everything that you would not find on LegalZoom. They understand all the various nuances, and they've read all the various case law involving different situations that occurred. So our recommendation is to call an estate planning lawyer the moment you decide you need to have a trust, or the moment you decide you need to have a will, or when, God forbid, somebody passes away and a will has to now be probated in surrogate's court. Always call an estate planning lawyer. That's the safest bet you can make. And by the way, in the next probably in 4 or 5 episodes from now, we're actually going to talk about how to find a lawyer and how to judge if they're a good lawyer or not. And that pretty much concludes our podcast for today. Thank you for listening.